Good morning. Welcome to the Bell and Pollock Legal Show. Gary Bell, along with Brad Pollock. Our law firm is Bell and Pollock. We are injury attorneys. And today we're going to talk about another injury subject, just like we do each week. Every week we bring the show to you to teach you and educate you and help you about injury subjects. And hopefully it gives you an equal level playing field with the insurance company. When once you've been injured, they fight your case. They try to reduce it. They try to mitigate it. And we try to expose all the things they try to do to you so that you know in advance what to do, how to do it, how to protect yourself, how to protect your family. Injury subjects. We're glad to do it. Don't forget, our website, championsofthepeople.com. That's championsofthepeople.com. You can contact us. You can get a free case evaluation if you want to. And don't forget also, after over 25 years, we've developed a legal game plan. Everybody that comes in our office has an injury, gets a legal game plan. And it fits your facts, your scenario, your situation, and you'll know what to do if you've been injured. You'll know what the insurance company is going to try to do to you. You'll know how this is going to work, and you'll know from the very first call you make to the insurance adjuster. By the way, we did a show on the very first call, what you should do and not do in the very first call to an insurance adjuster. You can go to all of our podcasts. You can listen to it. You can download them, play them for free. We do it for you. And by the way, we do it because these insurance adjusters that you face once you've been injured are highly trained. Don't think they're not. They know exactly what to do. They know exactly what questions to ask you. And what do you think? We've done a show on it before. What do you think when they say to you, well, we'll just send you a few forms. And you can just fill out these few forms and return them to us. We've told you what to do in the past. If you have any questions, give us a call at 303-795-5900. Okay, today we're talking about businesses. We're talking about landowners. We're talking about events. We're talking about concerts. We're talking about security premises and what somebody can do and what somebody can't do. We're going to get into baseball because baseball's right around the corner. There's a special statute in Colorado about baseball. Many of you probably don't know it, but there is. And so, Brad, let's cover the basic premises liability statute, which changed. We've said this before, changed the common law. So we're not going to go into the common law. That's a very fascinating area of law, but we're going to go into the premises liability statute. And, how do people recover once they've been injured? Let's say they go to Walmart, they go to a store, a big box store, event, sporting event, that sort of thing.
Well, the premises liability statute, which I think really what we're seeing, it is ever expanding. It's being applied to more and more activities that are on land or in a premises. And what we're finding is that the premises liability statute is eating up the negligence claims. It's saying that if you go onto somebody's property, whether it's for an event, whether it's for an activity or what it might be, or whether it's to buy something, and if you're going on that property and you're engaging activities on that property, you're there for a purpose as an invitee to do business, that somebody's brought you in, so they have a business, they brought you in to participate in or buy something in their business. You're an invitee, and that premises liability statute is going to take control over the negligence statute. Or the negligence cases. There's no negligence statute over the negligence cases. And it's going to say as an invitee that the landowner, and by extraction, they say not just the landowner, but the people acting on behalf of the landowner, the management companies, the companies that are carrying out the activity, the business owners, they have a duty to the invitee to guard against any known dangers or dangers they should have known about in the exercise of reasonable care. Now, that's very difficult standard for the injured person. And so we start getting into a very moving standard. It's not a set standard. There's nothing that says you have to have this many security people at the place. You have to have this many security people at the event. You have to have, they have to be trained as follows and identify what they're all about. Instead, it's a moving standard about what's the activity.
Right. And it's almost like trying to place a square peg in a round hole. And that sounds kind of stupid, but it's kind of true. Because under the old days, when you went onto somebody else's land, somebody's house, somebody's event, the sporting event, Denver Broncos game, a concert, then the landowner, and there's a broad definition of landowner. I'll get into that in a minute, but the landowner had certain duties to you, and they were determined by the common law of negligence, which is a little bit broader standard. So the legislature eliminated the case of Mile High versus Radovich, and that means in English language they got rid of the negligence standard. What they did is they imposed this other standard where you have to find that there's a dangerous condition on the property of which the landowner either knew about or should have known about, and that's if you're an invitee. So first you get classified. What's your classification being on the property? If you're a trespasser, you almost have no rights. If you're a licensee, which we're probably not going to talk much about today, you have limited rights. You have more rights than a trespasser. But an invitee is somebody that's there to transact business. So when you go into Walmart, you go into the grocery store, you go to a big box store or a sporting event, you're there to transact business. So therefore, you're an invitee. That charges the landowner with the highest duty of responsibility to you, but still it's been reduced and it's harder for the injured victim to recover.
Much more difficult than what it was under the Mile High case. Obviously, it was the change the legislature made was a very favorable change to landowners, to business owners, and to insurance companies. Primarily to insurance companies who were saying, we're going to have to keep raising our premiums if you let people be able to have a cause of action or be able to collect for the negligence of our people. You have to go further than that. You have to make that negligence something that they, for an invitee, either knew about or should have known about in the exercise reasonable care. And you've got to be careful with that because that's a very difficult standard to meet.
Right. Yeah, go ahead.
And so we talk about things like going to the baseball games.
Right.
Everybody's going to go to a baseball. Well, I can't say everybody out there, but a lot of people are going to baseball games this summer. What's your protection? There's at least one statute that directly deals with it.
Right. And I want to give you everybody an example, and then we'll get into the baseball statute here in a second, and some other examples that you're going to find very interesting. So the general example is, let's just take a grocery store. So you're an invitee. I mean, you're there to transact business. They owe you the highest duty of care. All right. So if somebody spills some liquid on the floor or drops grapes, very slick, going to probably cause an accident. So, but the store says, well, we didn't know about it. No, nobody told us. The person that spilled it didn't tell us. They ran away. They walked down the aisle and they're gone. We don't know. We didn't know about it. So there's the part of the statute that kicks in, that the liability for this dangerous condition, which it exists if the landowner either knew about it or should have known about it, and they should have known about it. They're under a duty to police their aisles. They're on duty to pick up, and that's why you always hear these announcements. There's a cleanup on aisle 6, etc. They got to get to it now. So you take that a step further, Brad, over to baseball. We've got a specific baseball statute that changes even the common law, changes Mile High versus Radovich, changes the dangerous condition of premises possession a little bit, and let's talk about that.
Now, I was not able to find a statute for hockey. I wasn't able to find one for football or basketball.
Much different.
But baseball, you can tell that there was a drive back in those days when the team was first coming in to make sure we got a team here to try and help the owners to be a safeguard against certain events which might happen. And so, the Colorado Baseball Spectator Safety Act of 1993 came in, which in essence it says if you get hit by a ball or a bat, you haven't got a claim.
Right.
Forget it. There's nothing you can do. As long as the team post signs saying, be careful, you might get hit by a ball or a bat, then you just have to live with, if you get hit by one, you get hurt. That's what's going to happen.
Right. And there's a warning it's kind of unusual in the statute. It actually gives the warning you're supposed to give. Most statutes don't do that. And it starts off by, under Colorado law, a spectator of professional baseball assumes the risk of any injury, and it goes on. I'm not going to bore you with that. But what I am going to tell you is, it's just like the Skiing Act, and we're not talking about the Skiing Act right now, but it's comparable, because you assume the risk when you walk into Coors Field, when you walk in to see the Rockies or any baseball team. You assume the risk of what they call in the statute the inherent risks of the sport. The inherent risks of the sport. And so you can see that's litigable. What does that mean? But it certainly means if you get hit by a foul ball or a flying bat, you're not going to be able to recover.
Well, baseball the legislators made it so you don't have a question about baseball. Now, do you assume it in hockey when you have a puck flying off the ice or when you have a stick broken there? But when we talk about security of the baseball, it's a different story.
Different story. Good point.
Now we're talking about if in any given time, 30, 40,000 people coming together. They're walking through the parking lots. They're walking down dimly lit streets. They're walking down through a parking lot that you hope is well lit. They're walking into a stadium. They're going up some escalators at times. They're going on elevators. During the game, people are drinking beer. They're participating in a game. They're rooting for their team. They may be causing problems for the ones who are rooting for the other team. And the question is how much security needs to be there and what needs to be the protection of, and when we talk about it, baseball games, you can talk about it at hockey games. You can talk about it at football games. I ask yourself, should there be more security when the Broncos are playing the Oakland Raiders than when they're playing the New York Jets? Should you have more security when they're playing San Diego Chargers or they're playing the New Orleans Saints? And why do you ask that? Well, what are the rivalry games and what's the chance that you may have injury and what security is required?
Right. So we got a break coming up, but think about this, and we're going to talk about this after the break. Think about the fact of you going to a professional game today, Broncos, Rockies, Avalanche, whatever. Think about the fact that there's no security. How would that sit with you? You just walk right in, no security. Versus intense security, searches, seizures, all that kind of stuff, wands, protections, pat downs. Think about those two extremes. We got a break coming up. You're listening to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. We're glad to bring the show to you every week to educate you, to try to help you, give you an equal level playing field with the insurance company, because once you're injured, you need experienced professional attorneys on your side. I tell you what, give our legal game plan a chance. Come in and see us. It's free. If you've been injured, we can give you your legal game plan, and it's pretty cool because then you'll know what to do. You know what your rights are. You know what the insurance company is going to do, and we've developed it, and it's taken over 25 years to develop this point by point. We go over it with you. We cover it with you, and you understand what you need to do. Our telephone number, 303-795-5900. In the mountains, it's 970-870-8989. We do car accident cases, big ones, medium, small ones, all over the state of Colorado. We do workers' compensation cases. Give us a call. Bell and Pollock. We are Colorado's premier injury law firm, and we are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it? With all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or if you prefer, lunch served in that old-fashioned homemade style. All made fresh on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash brown special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi, just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
You're on your way to the store, then boom, you're T-boned at 45 miles per hour. Instead of shopping, you're on your way to the ER. Then comes the doctor visits, prescriptions, therapy, diagnostics, ongoing treatment, and the limitations. You have range of motion problems. Then the ultimate insult. The insurance company makes you feel like the crash was your fault. You need a legal game plan. You want a legal game plan. At Bell & Pollock, we've used over 25 years of experience to develop a legal game plan just for you. Our game plan has injury rules, rules of treatment, rules of claims, insurance company rules, litigation rules, rules they use to beat you. Now you can have them and know them and use them to protect you and your family. Our Bell & Pollock legal game plan gives you the rules the insurance company doesn't want you to have, or know, or use. But guess what? We do. At Bell & Pollock, success is no accident. Find us at championsofthepeople.com. That's championsofthepeople.com. Get your free initial consult and your free legal game plan. We'll help you. Good morning. Welcome back to the Bell and Pollock Legal Show. We are injury attorneys. We're glad to help you. We're glad to talk to you. Give us a call. We'll talk to you. Come in for a free initial consultation and a free legal game plan for you on your injury, your case, your situation, and you'll understand what to do and what you shouldn't do. It's just that simple. We've developed this over years. It's our free legal game plan. Give us a call. We'll be glad to talk to you. Today we're talking about liability at events, liability at premises, liability at stores, liability at sporting events, concerts, that sort of thing. And I asked you the question right before, what would you think if you went to a concert or an event and there was no security? How comfortable would you feel in this day and age when you get searched at the airport, you get searched when you travel? How comfortable would you feel just walk in and sit down?
Well, and you know, as much as we hate having those people there, we hate standing in lines, we hate going through that process, we turn around and we're very thankful that once we're through the process and we've gone down the concourse or we've gotten into the game, that we feel there's a measure of security. That's an important basis and something we expect. I believe that if that kind of security is not there, if they're not doing that at a game, that organizer or that team has a very, very high risk of being held responsible if somebody gets hurt as a result of something being brought into that stadium that should not have been brought in.
Right, and we're talking about, I mean, we hate to use it, we were talking about bombs, we talk about those type of events, those type of injuries, but also, let's narrow it down a little bit. You go into the event and maybe somebody gets in a fight with you. Okay, so I mean, that's not a bomb situation. Clearly, they're there to prevent bombs. Clearly, they have a duty to prevent that. Then they say, well, we didn't know there was going to be an attack in Section 233. We didn't know this was going to happen. We didn't know this person was viable. So it almost boils down to a foreseeability doctrine. It's got to be tortured. It's got to be a square peg in a round hole because of this premises liability statute in Colorado. The legislature decided that. But you know, Brad, if it's foreseeable, and we need to talk about that this person, maybe the person in 233 had been in a fight before. Maybe they were known to be dangerous. Maybe they told the security people, keep your eye on this or they should have told the security people.
Knew or should have known or had knowledge of the risk, the danger. And that's a big problem. Well, Gary, one of the things that's interesting is when we talk about those guards that are at the games, when we talk about those license or the security guards that are at the games, do they need to get a license? Do they need specialized training? Do they have specialized training?
Great question.
Even if they don't. Colorado law really doesn't require them to be licensed. It doesn't require them to have any kind of specialized training. You can just get anybody to come do it. And when you're sitting at a game and you see somebody get unruly and start mouthing off or throw a beer at somebody, or challenge somebody, you start looking around immediately for the guards. That's what you do. Well, do the guards have to be there? And if so, when the guards get there, do they know what they're doing? When they're at the gate, looking at your stuff and checking to make sure you're not bringing anything dangerous into the game, are they really competent to be doing that? And what's the requirement to do that?
Putting the square peg in the round hole, you got to prove there was a dangerous condition, basically. And I'll guarantee you, these landowners, I mean, let's just take the big sporting events, the Rockies, the Avalanche, Pepsi Center. I guarantee you that if they got sued, they would tell you they have no duty. In their pleadings in court, they would say they have no duty or obligation to provide any security. But do they really believe that because they provide the security? And what was your answer to the question I asked you? What was your answer? Would it be acceptable to you if there was no security at these big events, concerts, whatever you want to talk about? Would it be acceptable? So they know it's not acceptable. They know that creates a dangerous situation and a dangerous condition, and that's why they have the security.
And that's what you have to look at if you've been hurt in one of these venues. And when I say hurt, I mean in a number of different ways. Have you been hurt as a result of somebody else hurting you? Or do you, or some other participant some participant in the game hurting you? Have you been hurt as a result of somebody who came to watch the show hurting you? Have you been hurt as a result of the way the security guards have handled you when they've decided that you're too unruly or they don't like what you're doing, or for some other reason they've zeroed in on you? All these things are questions that have to be addressed when you start getting involved in who's the security guards, what security guards are there, and are they licensed? Do they have any knowledge? Do they have any background? Do they have any experience? What happens when you walk out in the parking lot and you get hurt in the parking lot? And that hurt could be what happens if you get hit while you're walking through the parking lot and a car hits you in the parking lot versus what happens if somebody mugs you while you're in the parking lot.
Right. So if you get mugged in the parking lot and there's no security and there's no police that come for 30 minutes, is that okay? Is that reasonable? How about 2 minutes? Is that reasonable? Let's put yourself in the stands of a sporting event. And as Brad said, somebody starts to mouth off at you. You don't want anything to do with it. They still do. They throw beer on you. They hit you. And if there's no security to even be there or they don't respond for 45 minutes, is that acceptable? Is it foreseeable that in one of these events, somebody's going to get angry, somebody's going to get mad? Is it foreseeable? And if it is, then there should be security people there and they need to be responding timely.
And one of the things that you need to do when you start getting involved in a case like this is you need to find a lawyer who's going to ask some basic questions. And the first questions that the lawyer needs to ask is, how much security was there to begin with? And when I say how much security, I mean, first of all, the number of people that were there. What were their qualifications? Where were they stationed? What were their responsibilities?
And what was the time to respond and how did they do it? You know, they have ways to call the police, but I want to go back to this baseball statute a second, Brad. So you can't recover for the inherent risks of anything in the baseball game. So a foul ball, obviously, everybody would probably say that's an inherent risk. But remember the case at Coors Field a few years back when people were leaving the escalator malfunction and started flying people and throwing people everywhere. So would that be an inherent risk of a baseball game? Probably not. No.
Now the question comes up next. Should anybody have known, or should they have expected or reasonably known, in the exercise of reasonable care, known that particular escalator was going to stop, was going to come to a jerk like that? Now, you have to get behind the scenes.
There you go. You're right, Brad, because you got to get behind the scenes. You got to go to the inspections. They know they have a duty to inspect it. When was it inspected? Did they find deficiencies in the inspection that they didn't correct? Did they not correct them timely? Did they correct 9 of them out of 10 and leave one? We'll fix that in 2 games or 3 games down the road.
Well, I compare it a lot of times to people on the most common thing that you deal with. And, we can go through a number of things, but let's talk about your car. If you never service your car, you never take it in for anything, do you and can you expect it to break down? Can you reasonably foresee that it'll break down? The answer is yes.
Sure, of course.
Now, if you take your car in every 3 months, every 6 months, every 4 months or whatever, every 5,000 miles for an oil change and to be checked and to go through the requirements of the owner's manual, then should you reasonably expect your car to break down? Probably not. But the difference is, are you maintaining your car?
Right.
Are you caring for it? If you're not caring for it, you're looking and say, okay, at some point this thing's going to break down because I'm not doing anything and I'm going to be stranded or somebody's going to get hurt.
And immediately after that incident at Coors Field, all the venues started prohibiting the loading onto the escalators. They hold certain people. They stop people until the other people get off or get wherever they're going, up or down. And so they're created the duty. They're created the implication. They're created the cause of action and the liability.
And those people are your security people.
Those are the security people.
They're watching how many people get on that escalator so you don't overweigh it. You don't have it too heavy. You don't have too many people on it.
I guarantee you, if you're at a fan at let's say a football game and another one gets mad at you, throws beer on you and starts attacking you, you're going to want security. You're going to want some help. You're going to want the police. You're going to want security, and you're going to want it reasonably fast. I mean, you don't want it in 30 minutes when everything's been done. You don't want it when the perpetrator's gone, when the perp is missing. You want some help, and you don't want to suffer any bodily injury yourself. Then the landowner says, well, wait a minute. We didn't know this person was dangerous. We had no idea. Maybe they have a criminal record. We now know that, so we're going to bar them forever. But we didn't know that at the time. But you didn't respond for 36 minutes.
And that can be the difference. It can be difference between the difference can be also, look, you're at a game or you're at a show or something, and somebody gets mad and they throw a drink at you, and the drink gets on you, and you have a drink all over you. Okay, where's security? Security should be there. If it's properly controlled, security can get there. Now, let's say you have an event where they're not having proper security, or where security is not properly licensed, not properly trained, doesn't know what they're doing, or they haven't bothered. Next thing you know, it escalates from the person just throwing something at you to walking over and hitting you and beating you up, causing the injuries like the Dodger fan had at San Francisco.
At the San Francisco game out in L.A.
Yeah. The question is, when should, not just if there is security, to stop the cup from being thrown to begin with? Do you have security, or do you have controls over how much beer is being poured? How many beers this person has? Do you have the same person serving the beer in that section? So he goes, I've just given this guy during the game 4 beers. I'm not giving him a 5th. But the next question is, if in fact it gets out of hand, how fast do you have security available to take care of the problem, to make sure that it doesn't escalate to something that's going to be a much worse injury? And if you had security at the gate, to make sure they don't have a weapon with them when the fight breaks out.
To begin with. All right, we got another break coming up, but I want you to think about something before the break, and we're going to talk about it afterwards. I want you to think about the fact that you've got the situation where do the Broncos have a statute that protects them from inherent risks of football? Do the Avalanche? Do these other venues other than baseball have such a statute that protects them? We're going to answer that when we come back from the break. You're listening to the Bell and Pollock Legal Show. We are injury attorneys. We're here to help you. Every day we've developed a legal game plan. If you've been injured, we can give you our legal game plan. It's going to benefit you. You're going to know what to do. You're going to know what not to do. You're going to know how to approach the insurance company. You're going to know how to win your case. You can give us a call anytime, 303-795-5900. Our website, championsofthepeople.com. And if you ever want our free book, we've written a free book. You can go to our website, championsofthepeople.com. It's called Don't Get Hurt in the Accident Twice. Once in the accident and again on the insurance claim. It's got a lot of good tips in it. You can have that for free as well. We are Colorado's premier injury law firm, and we are your champions of the people.
Ready for an extraordinary lunch? As fast or as slow as you want it? With all fresh ingredients? Caitlin's Restaurant has it all. Express lunches that won't keep you waiting. Or if you prefer, lunch served in that old-fashioned homemade style. All made fresh on the spot. Whether it's a fresh-made sandwich with homemade chips, quesadilla loaded with cheddar or jack cheeses, or scratch-made soups, you'll find everything you love at Caitlin's. Caitlin's is located on Mississippi just east of Colorado Boulevard next to Bookies. How about green chili chicken stew? Think about a variety of fresh-made sandwiches or 11 different kinds of burgers made to order with 1/2 pound of the finest USDA choice lean ground beef. You might favor a homemade New Mexican recipe with carne adobada burritos, chicken enchiladas, carnitas burritos, served with hash browns, special recipe beans, cheeses with guacamole, and your choice of homemade red or green chili sauces. For those who prefer the lighter side, there are fresh made salads and lighter fares, sure to delight. Try Caitlin's for lunch or breakfast on Mississippi, just east of Colorado Boulevard next to Bookies. Call 303-798-6600. You'll love it every bite of the way.
You're on your way to the store, then boom, you're T-boned at 45 miles per hour. Instead of shopping, you're on your way to the ER. Then comes the doctor visits, prescriptions, therapy, diagnostics, ongoing treatment, and the limitations. You have range of motion problems. Then the ultimate insult. The insurance company makes you feel like the crash was your fault. You need a legal game plan. You want a legal game plan. At Bell & Pollock, we've used over 25 years of experience to develop a legal game plan just for you. Our game plan has injury rules, rules of treatment, rules of claims, insurance company rules, litigation rules, rules they use to beat you. Now you can have them and know them and use them to protect you and your family. Our Bell & Pollock legal game plan gives you the rules the insurance company doesn't want you to have, or know, or use. But guess what? We do. At Bell & Pollock, success is no accident. Find us at championsofthepeople.com. That's championsofthepeople.com. Get your free initial consult and your free legal game plan. We'll help you. Good morning. Welcome back to the Bell and Pollock Legal Show. Gary Bell, Brad Pollock. We are injury attorneys. Our law firm is conveniently located basically I-25 in Orchard. We have an office in Steamboat Springs. We do auto accident cases, big ones, medium, small ones. We do them very well all over the state of Colorado. We have for years. And we also do workers' compensation cases and any type of injury case. You can give us a call at any time. Okay, right before the break, we were talking about, do the Broncos have a statute like this baseball statute that you can't recover for anything except the inherent risks of football? No. And what about the Avalanche?
None. The Avalanche don't have a special statute. Why all of a sudden was there a baseball statute? Well, like we said, back in the 1993 when they wanted to bring the team in, or the 1990s when they wanted to bring the team in, you had owners who were looking, saying, we don't know if we want to be subject to liability.
Right, and then we had that tragic accident in hockey. It wasn't in Denver, but it was in another hockey city, and I frankly don't remember the city or the team, but they shot a puck out of the arena, hit a young girl, in the head and killed her. Very sad, very devastating, very tragic. So why do you think they have nets now? I mean, of course they care. They care about their people, and they put the nets up, but what do you think their legal duty or obligation is to put the nets up and to do that? Because there is no statute saying, hey, you can't recover except for the inherent risks of hockey, and there is no statute saying you can't recover except for the inherent risks of football or sporting events or concerts.
And you better believe there's some engineering involved in those nets. You better believe. And let me tell you something. The statute for the baseball team probably would not have any weight if you showed up to a baseball game for the Rockies and you found out they had no backstop. It had been completely removed, so when the pitcher's throwing the ball to the catcher, if he misses it, just comes straight into the stands. You'd probably find there that statute wouldn't have much value, because what's going to be required is the team still have some responsibility to put some protections in for their fans.
Reasonable protection, so that they can't net the whole field, but they can net where the fastballs are coming and the foul balls are coming. But the big ones that go into the third deck, they can. That's why they got this statute passed. Okay, if you've been injured, give us a call. Gary Bell, Brad Pollock. Our law firm is Bell and Pollock. We're glad to do this show. But, let us put our legal game plan that we've developed over the years in effect for you. You can understand your rights. 303-795-5900. In the mountains, 970-870-8989. Or our website, championsofthepeople.com. We'll see you next week.